the brother here.
Yes.
So if I may begin again, the two questions which arise in respect of this appeal. Firstly, does the CCJ have jurisdiction to hear this appeal from a decision of the Court of Appeal? And secondly, did the Court of Appeal have jurisdiction to entertain the motion filed by the first respondent? I think it is all agreed that the CCJ is not an institution established by the Constitution of Guyana, which, by virtue of Section 8 of the Constitution, is the supreme law. The CCJ was established by an Act of Parliament, number 16 of 2004, pursuant to an agreement establishing the court, which said agreement is incorporated in the legislation. I wish to take the court to Part 3, Article 15 of the agreement, which speaks to the appellate jurisdiction of the court and provides that, and I quote, "In the exercise of its appellate jurisdiction, the court is a superior court of record with such jurisdiction and powers as are conferred on it by this agreement or by the Constitution or any other law of a contracting party," unquote. Neither paragraph 2, which speaks to appeals as of right from decisions of the Court of Appeal, and I'm referring, of course, to the Court of Appeal, to the CCJ Act, nor paragraphs 3 and 4, which speak to leave following leave granted by the Court of Appeal or to the CCJ, speak to election proceedings as part of or included in the CCJ jurisdiction. Of significant importance is paragraph 5, which states, and I quote, "Nothing in this article shall apply to matters in relation to which the decision of the Court of Appeal of a contracting party is, at the time of the entry into force of the agreement, pursuant to the Constitution, or any other law of that party, declared to be final," unquote. And that jurisdiction is reinforced by Section 4.3, which says very clearly that nothing in this act shall confer jurisdiction on the court, and I'm referring to the Caribbean Court of Justice Act, to hear matters in relation to any decision of the Court of Appeal, which at the time of entry into force of this act was declared to be final by any law. If we take a leap backwards to the Guyana Constitution, which was promulgated in 1980, we find Section 177, subsection 4, which provides that the Court of Appeal shall have exclusive jurisdiction to hear and determine any question as to the validity of an election of a president, and any decision of that court under this paragraph shall be final. So that constitutional section makes it very clear that the Court of Appeal's decision in respect of issues raised as to the validity of an election of a president are decisions which are final and cannot and ought not to be appealed to any higher body, particularly the CCJ. Now, at the core of the first respondent's notice of motion, as I understand it, filed in the Court of Appeal, the relief which was sought at paragraph B was an interpretation of Article 177(2)(b) of the Constitution in relation to the election of the president. And we know that the words which were being sought to be interpreted, if more votes are cast. So that was the question which was being asked and put very succinctly. The Court of Appeal, in its decision, simply interpreted the words to mean, and I quote, if more valid votes are cast. This was the specific relief which was given, because there were no coercive orders made by the Court of Appeal, and in giving that interpretation, the Court of Appeal was looking at the broad meaning or the words which were used in Section 96 of the RPA. It is our respectful contention, therefore, that what was sought was an interpretation of a constitutional provision. And as such, we submit that the Court of Appeal under Section 1774 gives to the Court of Appeal in no uncertain terms the jurisdiction or exclusive jurisdiction to hear the motion which had been filed by the first respondent. And we go further to say that the decision on this matter will be final, because Section 4 makes it very clear that the Court of Appeal shall have exclusive jurisdiction. The issue therefore arises of whether reference to the words validity of an election refers to the process or the election process, or should it be limited to the final result of the process. The second option is what the appellant seeks to convince the court of. But I ask, what harm in giving a liberal interpretation to those words, taking into consideration, and I think we all accept, the need to resolve the election issues speedily? I go further, may it please the court. The case of Holland versus the returning officer during this whole election process in Guyana, there was no election petition which was filed. In that particular case, the returning officer fell ill. Somebody else was substituted, but the election officer could not validate or state very clearly that what the substitute had done was correct. And I believe it was my very learned friend who sought or in the intervention of the court in respect of this matter. So it was during the election process that this took place. We also have the case of Yulita Moore. Again, during this process, where the issue was whether or not CARICOM initiative was incompatible with GCOM's constitutional functions. That again was brought during the election process to ensure that the Constitution, provisions of the Constitution, were properly followed. It is therefore a respectful submission that Section 1775, subsection 5, which I believe my learned friend, Mr. Mendez, has made in his submissions, is not applicable and does not qualify the exercise by the Court of Appeal of its jurisdictions or powers under 177 subsection 4. Because all 177 subsection 5 does is to give a discretion, as it says, may, to Parliament to promulgate rules of procedure in respect of the Court of Appeal proceedings. And the mere fact that Parliament has not done so, to my mind, is immaterial, as clearly there has already been enforced rules of procedure which were in fact utilized by the first respondent.
Mr. Simon,
Yes.
there's a question which I would mind if you could help me with. 177.4 speaks about the validity of the election of a president. Who is the person about whom a question was being raised as to the validity of their election as president?
Well, to my mind, it was not the election of somebody as president, but the election of a president.
And who is that person?
Whoever it's going to be eventually, sir. Because what the process in that section of 177 provides for, especially we look at 177B, if there are two or more presidential candidates, which one of them is going to be elected as president? So it is not, to my thinking, that one subsection 4 addresses a particular individual who has been elected.
It does not.
It does not, to my thinking.
So
it addresses the election process in respect of a president.
Just a minute, Mr. Simon. The Court of Appeal is, by that section, by that article, empowered to inquire into the validity of no one in particular.
Yes, well, yes, Your Honor.
I see.
That's how I read it.
Okay.
So it is towards assisting the process of the election of a particular person or someone who clearly would have to get more votes than the other candidate.
So when it goes on to speak about
president.
When it goes on to speak about the qualification of a person, if we don't know the identity of the person, how can we begin to assess the qualification of someone whom we don't know, whom we can't identify?
With respect, I do not think that that is a proper way to look at it, because if we look at the section, what it says clearly, insofar as that question depends upon the qualification of any person for election. So the qualification of any person for election presumes that there is a particular candidate and one looks at the qualifications of that candidate.
Exactly. So what I'm asking is, who is that candidate in this case?
In this particular case, which is before us, it would be either of the candidates. It is the election process to elect one of them as president, not any particular individual.
Well, you say either, but well, you tell me, how many lists were there?
Because we were aware that there were two.
I see.
And I do not think that can be questioned.
Yes, go ahead.
So that when we read the section, the validity of an election of a president, doesn't say the president. It's not any particular person that it's referring to. And that is why I respectfully submit that it is the process of the election of a president.
And it doesn't say either a presidential candidate. It says a president.
It does say a president.
So doesn't it presume that there exists a president whose election, the validity of which is being questioned?
Mr. President, I think that would be giving it a very restrictive interpretation and meaning.
I see.
To limit it to that particular individual who is elected as president. So I would respectfully submit, especially as we're looking at the Constitution, that what we ought to be doing is giving it a liberal interpretation. Because what is important is that the process is followed, and more importantly, why the Constitution has provided that the decision by the Court of Appeal would be final and that the matter actually goes directly to the Court of Appeal is to ensure that in terms of time, that there is no wastage or there is no lengthy time frame for the court to meet.
Conceivably, this application could have been made the day before the elections.
I'm not too sure whether I would respectfully accept that, because I am submitting that when we speak of the validity of an election, we're looking at the election process. So the process would have begun.
Doesn't the process begin with nomination, with the formulation of the list? Those things happen well before the election date.
That is indeed so. So that we're looking at the whole process.
So you can make your motion under 177.4 at any point during the course of the process.
Yes.
And so you could make your application the day before the election day.
Yes, my lord.
And
from the time the candidate has been indicated,
nominated, put on the top.
Nominated, I think the election process begins.
And so the Court of Appeal would embark on this inquiry, and presumably they would stay the election date, is that it? Until it determines the matter?
If that is reasonable, given the time frame within which the election, that motion has been filed, it may well be necessary so to do.
I see. Yes.
Because if the court does not do that, it is possible that by the time the court gives the decision, the election process is completed. So if there is an urgency in respect of dealing with the matter prior to the full determination of the elections, then I think it would be within the discretion of the court to stay the election date. And I do not think that there is any legislation or legislative enactment which would prevent the court or restrict the court from so doing.
Mr. Simon,
yes,
does that facilitate a speedy, effective, and efficient process?
My respectful submission, it is, because what you're doing is that the court would then be addressing this matter at that stage, deferring the election date, rather than have the election process completed. And then we are in a quandary as to whether or not the candidate who has been elected was in fact duly elected. That creates confusion within the society.
So, but isn't that what always happens? That in the past, well, Mr. Jeremy couldn't point me to any case, I don't know if you can, where this preemptive challenge was done to the election of a governmental official. But isn't that what is always done? That you swear in the person and then you make your challenge in the interest of expedition and certainty?
That is what is usually done. I accept, may it please the court, but does that necessarily mean that is the only way that this can be done? When there is no legislative enactment that restricts the time frame within which that should be done.
Mr. Simon, in your construct, a challenge can be made to a candidate who even succeed in the requisite majority of votes, but we would spend time, delay an election, or a person who doesn't even become the president. And you think that that is a efficient and effective way any citizen on the level of stop the election in relation to a candidate who, on a counting of votes, will not even begin to come close. But you say that is a more desirable process to legitimize than to wait for a single person to be declared, and then whether there are bases to challenge and challenge.
My Lord, let us recognize that we live in a democratic society and that the electorate, if they decide that they want to make a choice, should be given the opportunity to make that choice. Personally, I would respectfully state that it would be better to do this during the process than to do it after the process is complete, because the court may find itself disenfranchising a whole section of our community, given our democratic process.
Let me tease it a little further. Would you say such an argument also apply to challenges to the High Court in relation to elections to the Assembly, i.e., prior to the declaration of any results?
I'm unfortunately not able to answer that question because I have not looked at that particular section. I am hoping that possibly the Attorney General, Honorable Attorney General, would be able to address the court on that specific issue.
Yes, go ahead.
Mr. Simon, before you go ahead, go on. Am I getting from you that you're saying that the redress under an election petition could have the potential of disenfranchising the people of Guyana? I thought that is what the result of what you're saying, but I don't get that impression that is what you want to say.
I'm grateful to your leadership, but what I'm basically saying is that in matters of that nature, the court has to take into consideration the democratic process, which clearly provides for the citizens, whether of Guyana or any other country, have a say in the process. And if the action of the court or the decision of the court at a time when the elections are over and a decision of that nature is made, it may very well have the effect of disenfranchising part of that population.
Mr. Simon.
So the discretion that the court will have to exercise, given the particular facts and the nature of the challenge which is being made.
Mr. Simon, may I ask you the same question I asked Mr. Jeremy, because again, to get an idea of the parameters. I posed the hypothetical question: suppose that the Court of Appeal gave a silly decision. Nobody's saying that they did. Some people think it's wrong, other people don't think it's wrong, but suppose there is a very silly decision. I think he said that even then, it's final. You can't do a thing. I just want to know if that is also the position of the Attorney General.
I think to properly answer that question, Your Honor, it is important that we look at the powers of the Caribbean Court of Appeal. Because the CCJ, there must be some authority which would allow the CCJ to intervene in a matter where the Constitution makes it very clear that the Court of Appeal has the final say. Let me say respectfully that the mere fact that a decision is granted by the highest appellate court does not necessarily make that decision right. We have to accept it because we can go no further. In the very same way, the Court of Appeal is given authority and power under the Constitution, the Supreme Court law, to make a final decision on a particular matter.
And if they go beyond that power,
we have to go very carefully to see whether the CCJ has the power to deal with that matter. I am aware, if I may say, that the Constitution, the Caribbean Court of Justice Act, indicates in Section 8, subject to Section 7, an appeal shall lie to the court with special leave of the court from any decision of the Court of Appeal from any civil or criminal matter. What does subsection 7 says? It says an appeal shall lie to the court with leave of the Court of Appeal from a decision of the Court of Appeal in any civil proceedings where, in the opinion of the Court of Appeal, the question is one that by reason of its great general or public importance or otherwise ought to be submitted to the court. So I accept that notwithstanding Section 4, subsection 3, and notwithstanding Section 177(4) of the Constitution, that one would have to examine whether the CCJ, who we are presently before, has any residual authority to address a matter where the final decision has been given. And I think that again would depend upon the interpretation that the court would have to make in respect of 177 subsection 4. I do not think I can put it any higher or any better than that.
Mr. Simon, just to clarify, when you say any interpretation the court will have to make in terms of 177(4), that the court is which court?
The court, the Caribbean Court of Justice.
So therefore, if I understand you, what you are saying is that when it comes to questions of the interpretation of the Constitution, of which Section 177 and 177(4) are parts, those are questions that the CCJ, under both the Act and Agreement, has jurisdiction.
It has a qualified jurisdiction, I respectfully state.
So which court determines what does 177 mean as a question of constitutional interpretation?
I would respectfully submit the Court of Appeal has that jurisdiction.
All right, yeah.
Okay, would you...
sorry, go ahead, Justice Smith.
Yeah, Mr. Mendes has argued that, okay, now, in the case of elections petition, in accordance with 163 of the Constitution, that goes to the High Court, and then there is an appeal to the Court of Appeal, and from there on, there is an appeal to the CCJ. That's what he said, because it never said that that decision of the Court of Appeal was final. An appeal from the High Court.
Indeed.
Is that how you see it too?
In respect of those elections, then clearly.
Yeah.
But the distinction is in respect of the Court of Appeal's determination, respect of the election, presidential election. The Constitution itself makes it clear that the decision of that court is final. That restriction is not there in respect of election of members of the Assembly.
I understand. Thank you.
What I would finally indicate to the courts is that the question of the interpretation of the provisions of the Constitution as the supreme law must be one that should be generous. And I'm quoting Sir Dennis Byron, the former president of the CCJ, in the case of Attorney General of Guyana versus Cedric Richardson. Sir Dennis, and I quote, says, courts at paragraph, it's on tabs, paragraph 13, courts should be generous in their interpretation. The court should not be overly literalistic and restrictive, but should give effect to the meaning of the Constitution. And that is what we're respectfully calling on the court, to give a liberal interpretation on section 177, subsection 4. I will, we have filed written submissions, and with the leave of my very learned friend who appears for the first intervener, I adopt and commend his succinct answers provided at paragraph 21 of his written submissions in answering the issues which were raised by the Court of Appeal, by the CCJ at the case management conference. May it please the court, and I believe the Honorable Attorney General may have a few words to add to my oral submissions.
Yes. Yes, Honorable Attorney General.
Thank you, Mr. President, Your Honors. I would just quickly, not to detain Your Honors, just explain what the question posed by the President of the Court in relation to 163, the jurisdiction under 163 and the jurisdiction under 177. There's no conflict, Your Honors, because under 163, that deals with the elections of members of the National Assembly and also the allocation of seats, etc. But the President is not a member of the National Assembly. So the President, no question involved with the President could be taken in the High Court in relation to the exclusive jurisdiction of that court. That's why there is a separate and exclusive jurisdiction to deal with the presidential elections in the Article 177.4, and that was given to the Court of Appeal. So there's no conflict in that situation. What I wish to say, Your Honors, is that the question, I entered an opposition to the application for special leave. And that was principally on the question that the court lacked jurisdiction. And I indicated that any court, but especially our apex court, would also have to look, in the first instance, the first thing that the court ought to do is to determine whether it has jurisdiction. And Your Honors, we regaled you with that, with answers to that question, that you don't have respectfully jurisdiction. And Mr. Mendes, representing the applicants, didn't sign on to that, and several submissions that he has made to this honorable court. But laterally, in his reply, Your Honors, I don't know if Your Honors have seen that, Mr. Mendes has purported to concede the point that we have been arguing since the affidavit in opposition, that the Caribbean Court of Justice did not have jurisdiction in fact. And Your Honors, that would be on the page 3397 of 3408 of the document filed by Mr. Mendes. And he said in particular that the intended appellants agree with all three respondents that by virtue of Section 4.3 of the CCJ Act, this Honorable Court was not vested with jurisdiction to hear any matters in relation to any decision of the Court of Appeal, which at the time the CCJ Act came into force was declared to be final. They therefore agree that this Honorable Court does not have jurisdiction to hear any matter in relation to a decision made by the Court of Appeal under Article 177(4) of the Constitution. They also agree with the first respondent's submissions that to the extent that any decision of the Court of Appeal under Article 177(4) is final and unappealable, this Honorable Court does not have jurisdiction to grant special leave to appeal. So this is a great concession, albeit that subsequent to that, Mr. Mendes is saying the appellant's case is that the Court of Appeal did not make a decision on Article 177(4). Since in the circumstances of this case, it had no jurisdiction to act on Article 177(4). The finality clause in Article 177(4) therefore does not apply. In other words, if it's saying the finality clause does not apply, he's trying to say that the CCJ should then have jurisdiction in this matter. But Your Honor, that would be tantamount to going in directly to something that you couldn't get directly. And in any event, in terms of the court's first remit to determine whether it has jurisdiction, he has agreed with us that the court couldn't have jurisdiction. I am respectfully submitting, Your Honors, that for the court to deal with that aspect of that the Court of Appeal did not make a decision and it did not have jurisdiction, that would be venturing into the merits of the purported appeal from our Court of Appeal. And the authority for that, Your Honor, is the UC Koyana case that we had cited earlier, and that is reported at 2553. And the judgment of Chief Justice Dan Japan, and when he had to deal with the question of the qualification of the president on the one hand or the interpretation of the Constitution, and he said that an examination of the supporting affidavit to the motion does not disclose either of the two issues specified in Article 177(4). This article gives this court power to try matters relating to these two issues and no more. It does not include the question relating to the taking of the oath by the president in order to permit him to carry out the functions of the office of the president. And this is what they concluded. Because of these reasons, I have arrived at the conclusion that Article 177(4) does not empower this court to try this matter. I will therefore decline jurisdiction. And since I have so done, I do not think that I have the jurisdiction to rule on the merits of the case, and I decline to do so. I will dismiss the application. Your Honors, I am respectfully recommending the decision in the Court of Appeal of Justice, then Chief Justice Dan Japan since 1980. It's a good vintage. But it is clear that if Your Honors were to venture into the merits of what my learned friend, Mr. Mendes, has proposed and is in recent submission to you, the intended appellant's reply, that the appellant's case, this is really a remodeling of my learned friend's approach to this matter. The appellant's case is that the Court of Appeal did not make a decision. Your Honors would be going to the merits of the appeal emanating, purported appeal emanating out of the Court of Appeal of Ghana. And that, of course, Your Honors, we've all agreed that there is no jurisdiction where that has expressed to be final there's no jurisdiction in this honorable court or apex court to take jurisdiction in this matter. And so once the court comes to that decision and declines to take jurisdiction, then there's no basis for the court, as in UC Koyana case, to go further to rule on the merits of Mr. Menz's contention.
Yes, those are your submissions?
Yes, please, sir. Unless there's anything else on the question of, for example, just quickly, the question with re-recall. And Your Honors have cases in which Your Honors refuse to enlarge your jurisdiction. This honorable court has refused to enlarge its jurisdiction, especially under some means of inherent jurisdiction. And those are eminent cases decided by this honorable court. For example, you have the case of Estate of Marjorie Knox and Dean, where in that case it had to do with an appeal that was delayed in the Court of Appeal in Barbados, and an application was made on the basis that that was tantamount to refusing the appeal, and so they were seeking special leave to the CCJ, and Your Honor said you want to enlarge your jurisdiction because you didn't have jurisdiction to take an appeal from the High Court, you don't need a Court of Appeal. You also did that in the International Environments Limited and the Commission of Income Tax. You also refused to enlarge your jurisdiction there. In Ram and the Attorney General, you went at length to say the same thing, that when you were being asked to declare somebody ineligible, who was there for 4 years previously, he said the court didn't have any inherent jurisdiction to do anything like that. So this court is well sound in its approach. And I believe that in this kind of case, which is basically like a treaty, where we in the Caribbean sign on and we said we want the final court. Ghana says it wants a final court and we want the CCJ to be our final court. And in given the jurisdiction, all we did was to exempt this narrow issue of our elections. And I don't believe that the Guyanese people want the elections. Then don't forget this would have been there since 1966. So it was included in the inception in the 1980. We would have had to appeal to the Privy Council to do what? To determine our own elections. And similarly here, I don't think the Guyanese people, in terms of Article 1774, intended or expected. And that's why the Parliament made it final that matters of our election should go beyond our Court of Appeal. And those are just some of the things I wish to express, Your Honor. But you have a lot of authority showing where you've exercised tremendous restraint.
Yes.
You should restraint in relation to your jurisdiction.
Yes, thank you very much, Honorable Attorney General. It's about midday now, and we will take a break for lunch at this point, and we will resume at 12:45 when we would hear from Mr. Ramkaran or Mr. Jonas, as the case may be, and then Mr. Khan, and then Mr. Amo, Mr. Hossein, and then Mr. Mendez will reply. But we'd have a short break in the afternoon as well. I'm going to ask you not to press the red button, not to exit the call, but to mute your microphones and to also take off the video. But to bear in mind that, well, if everybody is on mute, then you wouldn't hear what is happening everywhere else. And if everybody takes off their their video, then you would not be privy to what everyone else is doing. So we take our recess now until 12:45.